Good afternoon and welcome to the Porzio Planning Monthly Webinar Series. My name is Deirdre Wheatley-Liss. I am a principal at Porzio and I'm thrilled to have you with us here today. We created this series with the idea of what can we do to be able to sort of better support our community. The idea that we came up with is that there needed to be a place where you could get good, actionable information about elder law, estate planning, special needs planning in New York and in New Jersey. So to do that, we really engaged in a three-step process. The first is that we created PorziOPlanning.com, and on there you're going to see that we have a whole page dedicated to the concept of a team, which is that it's not just one person to give you advice, but it's getting advice from lots of different perspectives. We also created this monthly webinar series where I'm able to invite guests who are much more knowledgeable than I in specific areas to talk about answers to the questions that our clients are asking. And then finally, my partner, Crystal West Edwards, has put together Care Conversations with Crystal, which is talking about care issues around aging loved ones and loved ones who have disabilities. So today's topic is Trust 101. What does a trust really do? I created a blog, my first blog, oh gosh, more than 10 years ago now. And the #1 post of all time is what is a trust? Because I know that there's a lot of questions around that. Some people think that trusts are for the Gates family or the Bezos family, and it's not true. Trusts are a tool that everybody can use in their estate planning, and by the time that we're done here today, you're going to see exactly how it is that works. Can you flip to the next slide, please? So what I'd like to do here at the top of that hour is I would like to introduce you to our guests who are professional trustees. They help individuals who have trust. They're joining us from PNC today. So Julia, could I ask you to introduce yourself first, please?
Absolutely. Thank you, Deirdre, for having us. It's always a pleasure to collaborate with you. As Deirdre mentioned, my name is Julia Savage. I've been with PNC for almost 8 years, all within the wealth management space, helping clients really discover what they need. Many times our clients are not aware that they are missing options. And we collaborate with people like Deirdre to ensure that your estate plan is in place. We have a team of professionals, and I have my colleague, Kimberly Walsh, joining us, who is our senior fiduciary advisor at PNC.
Thank you, Julia. And thank you very much, Deirdre, for inviting us to participate in this panel today. So as my colleague Julia mentioned, my name is Kim Walsh. I am the Senior Fiduciary Officer, and I am seated as part of the Millburn Wealth Management PNC team. In my role as a fiduciary advisor, I draw upon my experience both as a practicing attorney. I also worked within the judiciary for a number of years handling trusts and estates. And now I serve clients as part of a complementary team that offers trust, investment, financial planning, wealth planning services. So it's really our pleasure to chat with all of you today and discuss a little bit more about what a trustee really does and frankly what a trust is. So thank you, Deirdre.
Excellent, and I look forward to it. So before we get started, we're going to try a new piece of technology here, which is to try a poll question. It's a first, so let's see if it's going to work. So could you please run the poll? Look at that. Okay, so here's our question. Do you have a trust as part of your estate plan? You can select yes, you do, no, you don't, and I have absolutely no idea, in which case please select I don't know. I'll just give everybody a few minutes to go ahead and put that together. Excellent. So Alex, you're in the background there, so are you getting poll results in? So why don't you go ahead and can we show the results then? Well, maybe our technology isn't working as quickly as I want it to. So if we can either show the results or flip back to the slide. One of the things that I do want to do today is this really is a session, again, that's here to support the community. So in terms of that, what we want to be able to do is that we want to be able to have you ask us questions. So if you're able to then be able to ask us questions, this way we can address what's really on your mind and not just what it is that we think might be on your mind today. So with that, if we can flip to the next slide, here's our first question then. What is a trust? So a trust, I like to say that it looks like a family business. And oh, we do have our polling results here. Okay, so relatively evenly split. So Julie and Kim, so you know, 48% says yes, they have trust, 43% say no, and 8% say they have no idea. So for those of you who do have trust, this is what it looks like. I like to discuss a trust as the idea of being a mini family business. Think of your local, wherever you've been getting takeout from, because we're doing this during the pandemic. So whoever's been feeding you for the past 6 months. Family business, owned by the family, but a separate entity from the family. It's for the benefit of the family, but somebody in the family is running it. You can use that same idea to think about a trust for your family's wealth. We have 3 different roles with a trust. The first is the grantor. This is the person who actually creates the trust. The second is the trustee. The trustee is like the president of our family business that we have here. And then we have the beneficiaries, who are similar to, let's call them the shareholders of our family business. And now trust can come in 2 different flavors. We can have revocable trust, and that's a trust that I use in lieu of a will. It's maybe because you have real estate out of state. It's something that you use while you're alive. Then we have irrevocable trusts, which are either trusts that are created because somebody passed away, or they are a trust that you're creating for a specific purpose while you're alive, but because it's irrevocable, you can't get the money back. So maybe we're doing that for tax savings, for income tax reasons, for asset protection, or something along those lines. But when you think about the trust can own anything that you can. That's often a question I get. Can my trust own my business? Yes. Can my trust own my investment account? Yes. Can my trust own real estate? Yes, it can. And trust from a distribution perspective have 2 types of assets in them. So you'll see there on the screen, we have income and we have principal. So principal is the stuff that you originally put into the trust, and income is what you earn off of the trust. For the most part, that's going to be interest, dividends, distributions from S corporations, LLCs, rentals, and the like are income. And when you design the trust, you can say, this is what I want done with income in terms of the beneficiaries, and this is what I want done with principal in terms of the beneficiaries. And as we talk more today, the trustee then takes what your desires are, they put together an investment screen to meet those desires, and then they follow through with your desires in terms of what it is that you're doing. So when we're looking at that, the question then becomes, who should have trusts, okay? So I said at the top, I think that anyone should have trusts, and I'm going to tell you why. If you're looking at the trust there, the blue box that we have on the screen, and that sort of green box, the outside around it, think of that as an impenetrable fence that is around your money and keeping your money and your assets safe. When you create an irrevocable trust for someone else, whether you're creating it as part of your will, so when you pass away, or whether you're creating it during your lifetime, trusts have something called natural asset protection, which is to say that when the money's sitting inside of the trust, that none of the beneficiaries' creditors can access the money. Well, who might be a beneficiary's creditor? They're in the middle of getting a divorce, their future ex-spouse. It could be a situation where they start a business and there is a global pandemic unexpectedly and their business goes south. Whatever creditors that they may have as a result of that cannot access the assets that are in the trust. Unfortunately, I have a lot of young people who think that they're going to be healthy forever and they don't get enough healthcare insurance, and then they get sick. Medical bills can't go into the trust. Anything liability that happens. So the idea is that your family's inheriting the exact same amount of money, but by keeping it inside of a trust, no one else can get access to that. So if I have the question, who should have a trust? Kim, any other thoughts about that?
I mean, I think you articulated it beautifully. You know, at the end of the day, trusts are as unique as each one of our fingerprints. And as you think about our fingerprints, there's some commonalities in all of our fingerprints, but there's some uniqueness with respect to each and every one of our fingerprints that's on this call today. You know, whether it's asset protection, something that Deirdre just alluded to, or simply, you know, when we talk about the difference between revocable trust and irrevocable trust. When we think about the concept of protecting and ultimately executing on the wishes of the grantor, that's what a trustee does. The trustee looks at the blueprint of the document and in essence serves as a project manager or a contractor that's executing on the wishes for the benefit of someone else. And so that document, that trust document, is the guiding principle that ultimately will determine how we as trustees, using the highest standard of care, the duty of loyalty, the duty of impartiality, a fiduciary duty, make sure that we always put our interests of the trust above our own personal interest. And so getting back to your question, Deirdre, in terms of the other instances where a trust would be helpful, certainly when we talk about estate planning and we think about ultimately our demise, there's also a facet of trust that deal with revocable trust, dealing about incapacitation. So very often when we think about putting together a revocable trust and titling assets and the name of the trust, that might at some point funnel into an estate, and there's a great purpose for that. It also can be very helpful in the event that we as the grantor and ultimately perhaps the trustee can effectuate business on your behalf in the event you become incapacitated. These revocable trusts are very effective in allowing a trustee, again, bound to the highest duties of ultimately loyalty and impartiality and care, to ensure under the terms of the trust agreement the needs of that individual are taken care of, not just at death and not just in terms of creditor protection, but in the here and now, in the event that you're unable to perform, the functions of life, paying bills, dealing with creditors, taking care of taxes. Deirdre, anything else you want to add on that?
No, I think that's a great point, and I didn't even have it in my notes. So the idea with a revocable trust is that you're creating an opportunity for substituted decision making while you're still alive. And particularly for any of you who joined our seminar last month, the aging population is growing, and the people in the aging population ages 80 and older is growing. It's just where our demographics are going at this point in time. So by creating a revocable trust, that's not necessarily you can't use a revocable trust to protect your assets from your own creditors, but the goal here that Kim just outlined is that you can use it as an opportunity to be able to have somebody else be able to have control over your money with those project management guidelines. I love that idea, the project management guidelines, to be able to then use your money for you while you're still alive. I do have to add one huge caveat to that. In order for that to be successful, the trust needs to be funded. Now, what do I mean by that? The trust, the box that is on the screen, that entity, that legal entity, that separate family business needs to own the asset. So for real estate, the real estate needs to be titled into the trust. We do that with a deed. For an investment account, you need to open up an account in the name of your revocable trust and then move the account from your own name into the name of the revocable trust. And Julia, you can certainly talk about that because I know you help clients do that all the time. With your business, instead of you owning the stock or you owning the LLC interest, you would then assign it or transfer it to the trust. So that's a really great point, Kim. But the times that I see that somebody thought that they had a great plan, they didn't complete the loop by actually funding into the trust at the end of the day. Now, another reason that you fund a revocable trust, if you're doing a lot of reading on the internet, is the idea of avoiding probate. Now, we're sitting in New Jersey. We're sitting in 3 different places in New Jersey right now, but we're sitting in New Jersey. Probate is not a very expensive or difficult process in New Jersey. Kim actually used to work in our probate system, and it's, a visit to the courthouse, or right now it's just mailing to the courthouse. They send it back to you and you're pretty much done. Other states, however, that's not the case. So for example, if you decide to move down to Florida, in Florida, there's a supervised probate by the court, and it's a very expensive and lengthy process. So we might suggest you create a revocable trust, retitle the assets into the revocable trust, and now you get 2 benefits out of it. 1, substituted decision making with somebody else being able to look after your assets for your benefit while you're alive, and 2, reducing the cost, expense, and time that's associated with probate. So Julia, could you give us, because I know that you work directly with so many families, maybe an example of when a trust worked really well that might be somewhat unusual to our audience that they didn't necessarily think of?
Absolutely. One comes to mind right now that we're working on with, woman, never been married, had no family whatsoever, and really working with counsel, we guided her to have a revocable trust, because at that point, none of us know when our expiration date is. So we really worked with her to uncover her assets, which were all over the place, which that makes it even more difficult. But not having someone to help her really created a red flag for our team. And when it came to really ensuring that she knew, God forbid, she became incapacitated, that someone could pick up and pay her bill. And that's what we're doing. We were paying her bills. We ensured that we even go to the extent of going to her house and ensure that the nurses around her were actually taking care of her, paying her taxes. And she actually had a neighbor that was helping her a lot. And all of her assets were going to charity. She had a house. It was just a very complicated and sad story, to say the least. But our team really put our arms around her. And unfortunately, she just recently passed. And it came to the extent that she never, ever talked about her wishes of how she wanted to have burials, of what she wanted to do. And we were able to help her by understanding her trust, by understanding how she thought, on how to accomplish something that would help her and help everybody that loved her feel at peace when it came to her burial. But what I want to focus mostly is during her life, during the time when she was really sick, that trust is what protected her assets, it protected her care, and it guided us.
Excellent. You know, and again, and this is why we have those conversations, because even when we did the preview for this call, I have to tell you, we didn't talk about revocable trust at all. We only spoke about irrevocable trust, and it's a great point. So here's an idea then. You know, I'm thinking of a trust, you know, when I was sort of putting my notes together for this, somebody passes away, they leave the assets to their children, to their spouse in a trust. But here is an idea, particularly, you know, and again, when we look at the aging situation, women who are getting older and who don't necessarily have that family support around them, it's a tool that you can put into place to ensure that your wishes are not only known, because when you go through the process of creating the trust, you're asking those questions to really lay out what your wishes are, but making sure that they're actually going to be carried out. So that is an excellent point. Thank you. And I hadn't even really thought about that at all.
You know, if I could add one more thing to this discourse as we're chatting about this, we'd like to think, you know, as the trustees, we serve as these project managers, and we work off of these blueprints, this trust document that has been created by the individual who is interested in creating the trust, but it is counsel that ultimately serves as the architect in all of this. So when you think about the structure of this, you have an architect that's asking, you know, how do you want this house built? And what are the needs of this house? And ultimately, who are going to be the beneficiaries of this house? And the project manager, the trustee in a professional context, has that responsibility to deal with the house during its building stages when we're still alive, and in its fruition stages when we're no longer here and that asset has to be protected. And so it's a collaborative process that involves both the execution and the drafting and the conversations with our respective clients to ensure that ultimately their wishes are met, and that we have the direction in writing, in a document like blueprints, that we can work off of during both incapacitation and then ultimately, as Deirdre mentioned, when somebody passes away and that revocable trust in essence becomes irrevocable at this point. And so we go ahead and distribute per the tone of the document and the terms of the document to the beneficiaries, however that looks. So it's a very collaborative process that, like life, has a beginning, a middle, and an end.
So one of the things when I mentioned at the top as I was doing the introduction that we focus on the idea of a team, and that an individual needs to surround themselves with a team. And again, this has nothing to do with the amount of wealth that you have. It's really to do with the amount of knowledge that you don't have. Okay. I focus in the area of documents, trust, and estates. To your point, I am the architect of this particular project, right? Well, your accountant's your CFO. They really need to know what's going on with the project. And if we're able to get insight with them and work with them, an accountant might be able to say, have you considered XYZ, because they've been doing your filings for so long that you didn't think of to alert anybody about. carrying out the terms, how things, Julia, from your perspective, how things are going to be invested. And then whether you're using a professional trustee or using an individual as a trustee, and we'll talk about those options, every plan only works as well as who the trustee is, because this is the person who's actually carrying out your plan. So if we flip to the next slide, when you're giving consideration as to who should be a trustee, one of the things that immediately comes to my mind is, and we'll talk more about, who the people actually are. Somebody who shares your values is what I always advise my clients, because whatever document that I create, your blueprints to use your analogy, it's going to be very dry and it's going to be very two-dimensional because it's a black and white writing. Okay. The person who gives it life, who breathes the life into it, is the trustee. And in my mind, that's why I really wanted to focus on this topic, because picking that right person, group of people, whatever the case may be, to be able to be the trustee is very important. And before we flip over this, we actually have a question that I want to talk about, which is, are there any governmental agencies regulating trustee or an organization who vets the quality of the trustee? Because there's been, well, you can just read the news. There's a lot of very different treatment of trustees. So, Kim, I'd like you to talk about that from a professional perspective, but before you do, just in a general sense, the answer is no. If you have a trust document that's created and you have a trustee who's named, they're not reporting back to somebody on a regular basis as to what it is that can be done. The beneficiaries have access to ask the courts to supervise what it is that a trustee's done. But just in all reality, and this is why it's so important for who you pick as the trustee, if the money's gone, the money's gone. And if you find out that, yeah, you did a lot of stuff wrong and therefore the money's gone. I was just reading a case yesterday where I think it was just a published case that the estate started with like $850,000. And by the time any money was ready to be distributed, there was $6,000 left. So maybe the person didn't do what they were supposed to be doing in that particular instance. So a beneficiary has recourse, but a beneficiary isn't necessarily going to know what's going on if the trustee is not being transparent with them. And this gets into the idea, then, what does a trustee need to do to be a good trustee? We don't want to be going to court to say the trustee did bad things. You want to be naming somebody who's going to be a good trustee. So the world of trustees, who can be a trustee? A beneficiary can be a trustee, and that may make a lot of sense. So if I am creating trust for my 43-year-old son and my 47-year-old daughter, I've seen what their life is like. I feel that they're responsible. I see no reason that they can't be the trustee of their own trust. That's perfectly acceptable in New Jersey, okay? Maybe you want to name a third party as a trustee. So you might say, well, my kids are 18 and 22, even though they're legal adults, somebody else should really be helping out with this, and I'm going to name my sister. That's fine. You can name a corporate trustee, and Kim and Julia are going to talk about what they do as a corporate trustee. Or you can name some combination of the above, a beneficiary and a corporate trustee, a third party and a beneficiary, whatever the case may be. But if you're thinking about who's going to be your trustee, Kim, let's talk about the trustee's responsibilities, because this is a job that you just took on.
Absolutely. So look, at the end of the day, as I mentioned from the outset of the remarks, the trustee or the fiduciary has the highest standard of care that's laden on it. Those duties of care include that of a prudent, reasonable investor standard. We also have the duty of care, loyalty, and impartiality. Those are codified in both state statutes as well as the case law. And so to Deirdre's point, while there's no governing body per se, ultimately we have a duty as fiduciaries to do several things: to account to qualified beneficiaries, and that's in terms of notification, sharing statements, keeping them apprised of what's going on relative to the respective accounts; to ensure that we have a diversified portfolio when we're talking about assets that are being managed, investment assets such as stocks, bonds, cash. We certainly have a duty to file all requisite tax returns, be it both federal and state, as well as ultimately to ensure that any tax determinations that are made with regard to distributions that are coming out of, let's say, an investment management account that's titled in the name of a trust. Ultimately, We are governed by the terms of the agreement, as we've mentioned several times, that blueprint. Let's say we have to make quarterly interest payments out to certain beneficiaries. Not only do we have a duty to account and to keep them notified, we have to make sure that the assets that are being distributed from a tax perspective is being handled in a reasonable and prudent fashion. So there are a number of sophisticated, both administrative and financial responsibilities that are imposed upon a fiduciary, a trustee. And from a corporate perspective, the bottom line is that when a corporate entity such as PNC is named in this type of capacity, ultimately we have a duty to those beneficiaries and have the resources to effectuate the portfolio management, the tax strategies, the distributions, the legal review of the documents, because of the nature of the responsibilities that are imposed upon a trustee. I work frequently in a sole trustee capacity when PNC has been named as a sole trustee in an irrevocable trust or a testamentary trust, one that's come to life after someone has passed away. But very often, as Deirdre mentioned, PNC, my trustees, my colleagues in the office will also work with individuals as well, family members serving in a co-trustee capacity, to, as Deirdre's point earlier, to mention that ultimately there are documents that we work off of and have certain responsibilities that are imposed upon us, but those documents need to come to life. And they certainly come to life when we have the perspective and the participation of co-trustees that perhaps were family members, siblings, children, spouses of the individual that served as the grantor or the individual who established the trust. So I hope that kind of summarized for you, Deirdre, some of the responsibilities that we have from a fiduciary perspective, and certainly when we serve in a corporate fiduciary perspective.
So I'm going to want to unpack those, but when I see issues with problems with trustees, people being unhappy with a trustee, I have to say it comes down to communication most of the time, okay? Or like this, it comes down to communication or lack thereof. So Julia, I know that you're often working with the beneficiaries of the trusts. Yes. What kinds of questions are beneficiaries asking that the trustee should maybe be pre-thinking about, and this should be part of their communication that they're sort of doing all the time? So what kind of things do you find that beneficiaries maybe have some questions about?
So when it comes to a lot of the beneficiaries, as you mentioned, we have a lot of trusts that have been established for many, many years, even 40 years. And these beneficiaries often want to know what are their rights? How is this account being managed? And what is the income that they're allowed to have? What freedom do they have when it comes to anything in regards to the benefit? How can they utilize those assets? And as Kim and you have mentioned, when it comes to a trust, that's an instrument that the trustee needs to follow and really communicate and ensure that the beneficiary is aware of their rights. We do often work with the beneficiaries in helping them create a budget. Sometimes they are not aware of that they may have some discretionary and non-discretionary access to those trusts. So the trustee's job to really communicate and educate those beneficiaries. As you mentioned, sometimes they might be young adults that are not aware of what they have access to. And it is the trustee's responsibility to ensure that they do, in order to really guide them and for them to have access to it in the right way. The trustee has to be prudent. The portfolio also has to be managed to meet those beneficiaries. So it is our job to educate those beneficiaries in every single aspect of what they have and how that is being managed.
So I want to talk to you a little bit more about the budget. So when I'm representing somebody who's acting as a trustee, or even when I'm acting as a trustee, I have the beneficiaries create a budget every year so that I can understand what their needs are in terms of what it is that the trust can supplement. So you mentioned about discretionary and non-discretionary distributions. Can you just unpack that a bit for the audience?
Well, what have you seen, Deirdre? You know, that's a great question. What have you seen in your terms when it comes to the people that you're working with?
Yeah, so we may create a trust and we say in the trust that it's in the total discretion of the trustee. And we do that often because that provides the maximum asset protection, right? Well, that also means then that the trustee could just say no to everything. Now, Kim, to your point, that would not be within your duty of care and loyalty, presumably, to be doing that. But there are situations where people should not have access to money because they're going through a variety of life crises. So what we would suggest to a beneficiary is, you know, what are your needs for the year? Example, I want to go and I want to work for a charitable organization for the next 2 years because I think it's an important thing for me to do. But the charitable organization happens to be located in Los Angeles and I will not be getting paid enough to get an apartment in a safe area. Okay. Then in that case, I might say as the trustee, you should get a distribution every month of $2,000, right? And then presumably then the trustee speaks to the investment manager and says, I need you to invest this in such a way that on the first of every month, $2,000 is transmitted to the beneficiary. The beneficiary now has a stream of income from their trust that is appropriate for what it is that their needs are. And I think it's very important to set up those streams of income so that as a beneficiary, I don't feel like I need to give you a call every single time that something happens. Now, having said that, if my car got hit by a tornado, I need a new car, that's worth a phone call, right? But that's how I recommend from a communications perspective that you do things. And I don't know if you have any comments on that in your real life experience with clients.
Absolutely.
Yeah,
oh, sorry.
Go ahead, Julia.
When it comes to that, we actually do have a client, and it's a similar situation. She's a teacher. So the dad intended for her to be able to continue with her profession. Mind you, she's a teacher in New York City. And the quality of life that she's used to, she wouldn't be able to afford even a small apartment in New York City with her income. You know, she's doing fabulous work and helping children, but unfortunately, that doesn't pay the bills. So this trust is intended for her to do what she loves and for her to be able to afford the lifestyle that she's accustomed to. Mind you, yes, the trust is not intended for her to have a Ferrari to go back and forth from work, but it's intended for her to have a good quality of life and to be able to continue doing what she wants to do. So that's a perfect example that we are at this moment actually doing. So we do ask her to give us a budget. You know, we learn her spending patterns. And if something is out of the extraordinary, you know, even if it's health issues or a wish to go on a trip, we have a committee. We look at expenses, and oftentimes we are able to help that beneficiary accomplish those goals.
Excellent.
I know you wanted to comment.
No, I wanted to add that the key to all of this is, as Deirdre alluded to, is communication. And so many of these trusts are newer trusts that have just been established, and so obviously we're in, this is a new endeavor that has been established, and so you would think from the get-go there would be constant and good communication. The challenges are often in these testamentary and these older trusts, these legacy trusts, the trusts that have been around for generations. And so there's an educational component to make sure that the beneficiaries are aware, again, what our duties are, what the terms of the trusts are, and how we can ensure, whether it's a revenue stream issue, whether it's a distribution issue that Deirdre alluded to. You know, there are times, many of the trust documents certainly will allow for the distribution of income on a regular basis, and that can be something from a cash flow perspective that's very amenable to our beneficiaries. But you know, sometimes they don't always realize that under the terms of the document, assuming that there is express language to this effect that the architect would have put in some time ago, that we can make invasions into the principle of the corpus or the body of the trust for those needs of the beneficiary, be it health, education, maintenance, support. Perhaps it's, you know, suddenly unexpected medical expenses that have come this individual's way. Perhaps it's a need for this individual to move into a skilled nursing facility, and that the interest payments that go out on a quarterly basis are not going to be enough to cover. Those are the pieces of the puzzle, I think it's very important that a trustee, be it a corporate trustee or anyone serving on that role, communicates on a regular basis with the beneficiaries so they are aware of what is accessible for them, and ultimately how the distribution, we call it a discretionary distribution, would be handled for their benefit. Because again, these trusts have been set up for the benefit of an individual or individuals. There's certainly a responsibility for us to manage those assets and to ultimately follow the terms of the document to ensure that those beneficiaries are cared for in such a way that the grantor had intended to. So communication is the hallmark in all of this. And I think that's why, frankly, in our world, we have full-time staff that only handle trusts. These are full-time jobs that are multifaceted in nature, that have numerous requirements that I mentioned, but also the ongoing human element as well, to ensure that the beneficiaries are always apprised and feel that there's an open line of communication for their needs.
So I just wanted to make one last point on the communication, then we have a question that I'm going to answer. Going to your analogy, I do the blueprint, okay? That's the framework of the house, okay? It's not the interior design, it's not the paint color or anything else. I encourage my clients I call it a family love letter, okay? Sit down once a year, write a letter to your trustee. Here's what's important to me for how the money is used, okay? Because Kim, you just said, you need guidance, right? Julia, you're creating relationships with people, but what if you didn't really know them that well before you ended up being the trustee? Mm-hmm. Give some guidance to your trustee. It's important to me that my kids get a good education. Education to me is everything from culinary school all the way through veterinary school. It's important to me that they have an opportunity to travel and see the world. It's important that they engage in music. It's important to me that they're philanthropic. So they should be given money every year that they would then use to be philanthropic with those money. It's important to me that they engage in volunteerism. So the trust needs to be able to support that. It's important to me that they have financial security for their entire lifetime, which means that the trustee should then be investing and distributing the money differently based on what the person's age is, and to be able to have it there for their lifetime. Those are the kinds of things, that's where the trust really comes to life. And in having a conversation with people, that's why you need a team around you, because you may not necessarily discuss that with me, right? But maybe you got your financial advisor that you're meeting with every single quarter, and something comes to mind, say, hey, why don't you give a call back to the attorney so that the attorney can make sure that that's either in your documents or somehow captured in some way. So I do want to answer the one question that we have here before I turn to a couple, actually, Kim, that you had raised for me. So what if somebody sets up a trust in New Jersey but moves to another state? My favorite lawyer answer, it depends. If it's a revocable trust, then that revocable trust, presumably when you move to another state, you will then revise it just like you would a will to then be consistent with the laws of that state. If it's an irrevocable trust, an irrevocable trust has to live somewhere, but it can move just like you move, okay? So if you create an irrevocable trust while you're living here in New Jersey, and you have a trustee who's living here in New Jersey, that trust lives in New Jersey. The document will say it is governed by New Jersey law, and for tax purposes, it lives in New Jersey, okay? Well, let's say that you want to move your trust to Florida, okay? The document, if flexibly drafted, is going to allow you to do something called change the situs of the trust. The situs is just what state the trust lives in. So you can change the situs of the trust to Florida. Depending on who the trustees are, you can change the taxation of the trust to Florida. And then because it's under New Jersey law, in New Jersey, we have something called the Uniform Trust Code. So even though trusts are irrevocable, they cannot be revoked, it does not mean that they are unchangeable. Through the Uniform Trust Code, you can make significant modifications to a trust. Kim and Julia, you mentioned that you're dealing with trusts that are 40 and 50 years old. There is no way that whoever put that trust in place could have anticipated the lifestyles that people are living right now, right? So maybe the trust needs to be changed because the terms don't make sense anymore, either because the outside world has changed, maybe the tax laws have changed, or because the beneficiaries have changed. What if you have a beneficiary with special needs and you didn't have provisions for that? So an irrevocable trust can be changed, which is very important in being comfortable in creating a trust, that the trust can be changed by the trustee in conjunction with the beneficiaries if the terms don't actually make sense anymore for what they're doing. So Kim, I want to dig down before we get to talking about really who should be the trustee to really understand what these job duties are, okay? So one you said is that the prudent investor rule, and you need to be diversified. What does that mean in English? Kim, I don't know if that's a you question or Julia question.
I'm happy to take that down a bit of a notch. So at the end of the day, as we've said several times, we're held to a fiduciary standard, and in doing so, we have to make sure that the needs of the assets that we're managing come before anyone's needs, but the needs of the trust. The trust needs to be managed in such a way that is prudently and reasonably invested. And so typically when we have assets, let's say an investment management account, the goal of prudent investment management is a portfolio that is reviewed and accounted for and reasonably invested. The case law says, without getting too far into the weeds, that means a diversified portfolio, a mix of bonds and stocks and cash. Sometimes in the document itself, it's going to delineate for us how that is to be structured, what type of holdings can be in that particular trust. Sometimes it's silent, but in our particular wealth management office, we have portfolio managers that are assigned to manage those accounts at that reasonable investor standard. And perhaps, Deirdre, if that's, if we want to kind of unpack that a little further, I'd kick that back to you or Julia to discuss that.
I can absolutely add to that. A lot of the times when it comes to managing a portfolio and ensuring that it's prudently and meeting the beneficiaries' needs, we do a cash flow analysis. We have to test the risk of that portfolio. And we have to understand as fiduciaries, how many generations are we here covering? Is it just a one time at the end of the trust? Does it go to just the first generation? Or are we looking to their children's children? And at that sense, we really have to ensure that this money and the principal is protected, but in essence is creating enough income for the beneficiaries at this point. So that's where the portfolio manager really comes into place and allocates the portfolio and the assets to meet those particular needs while protecting the body of the assets so it can go to the following generations.
And I want to be clear, a trust doesn't just have to be invested in investable assets. So, often I'll have a beneficiary, they want to get, the home in the Poconos, okay? And the beneficiary might say to me, well, I'd like a distribution of $300,000 so I can buy a house. Well, the trust could take the same $300,000 and buy the house. The benefit there is that the house is still in my blue box on the prior screen with the impenetrable wall around it, so you still have the asset protection. Also sometimes, so a trust, it can have real estate, but also sometimes you have a specific asset that you want to be maintained. I want the family shore house compound to be maintained for all time. I have a business that I want the trust to continue to invest in. The trust can do that, but from a drafting perspective, when we're doing those blueprints, you want to make sure to identify that these are the types of assets and give the trustee the right, because of this prudent investor and diversification rule, to not be as diversified. We have some clients, they have worked for J&J. They've done very well for J&J. They wish to always have J&J stock, and they don't really want anybody ever to sell their J&J stock, which is fine. But then that's got to be in the document, because the trustee has certain obligations that you can change in the trust, but you need to communicate them so that they can be in there so that the trustee can change them. The next one, Kim, that you talked about is the duties of care and loyalty. Which I sort of say you need to put the beneficiaries in front of yourselves. And this is where trustees, I have to say, get in one of the areas where they get in the biggest amount of trouble. So can you sort of talk about what that duty of care and loyalty is, and maybe sort of give an example of how it is that you function in that role?
Look, at the end of the day, at this fiduciary standard, this is not at the best interest, let's say, of PNC Bank. This is in the best interest of that beneficiary, both the current beneficiaries, as well as, I think Julia alluded to this, any future beneficiaries. Very often these trusts will go on in perpetuity, meaning they could go on for generations, never ending, dynasty trusts. And so ultimately, through that prudent investor standard, whether it's the holding of a home, as you just described, or ultimately a diversified portfolio, or even a holding of a concentration of stock, if that is in fact what the grantor wants, we have to abide by those tenets in the respective document and ultimately ensure that we are doing everything possible to ensure the integrity of that trust and the lasting nature of that trust, be it for the lifetime of that beneficiary, which might, at their lifetime, may terminate outright, meaning just go outright to another individual or to, let's say, a charity, or ultimately to a successor generation. So we're looking at this from an intergenerational perspective very often, one that is going to ensure the integrity of the body of the trust as well as the needs of the beneficiary for this generation and going forward. So this is not a quick 6-month in and out endeavor for many of these trusts. There is an ongoing responsibility of loyalty and care to ensure the integrity of that trust for multiple generations.
So this actually leads to a question that we just got in from the audience, where if my spouse is named as the trustee, do they need to give consideration to the needs of the other beneficiaries, the remainder beneficiaries? The answer is yes, but how much? When we draft a document, generally speaking, that's for the benefit of the spouse and then eventually goes to other beneficiaries, we actually put a provision in there that says that the spouse is the primary beneficiary. And to your point, Kim, the trustee doesn't have to look at the interests of the other beneficiaries. They basically get what's left over at the end of the day. Now, that's not appropriate for all trusts, but for, let's say, I'm leaving my assets in a trust to my spouse. I want my spouse to have the benefit during their lifetime, and then only when they pass away should everything then be distributed to the children at that particular point in time. That might then be an appropriate term to put in there. But when you're acting as a trustee, I go back to my family business analogy. You need to keep the same level of records and documentation that you would in your business where you're acting as a trustee. Because at the end of the day, the money is not your money in your pocket. It is a business that you are charged with operating. That business gives you benefits, whether it's the asset protection or because we created this trust for very specific tax savings purposes, but you need to operate it like a business at the end of the day. Now, that doesn't mean that it's got to be overwhelmingly difficult, but you should be keeping a spreadsheet of all your expenses. You need them for tax purposes anyway. Some people use QuickBooks. That's perfectly fine. You should keep copies of all of your investment statements. You should meet with the investment advisor at least once a year to say, hey, does this continue to make sense to have this mix of stocks, bonds, cash, given what's going on in the broader marketplace? The reason that you do that is the same reason that I meet with my investment person once a year, is that I don't know a lot about investment, and that's why I've retained them to be able to help me. So the trustee has to do that. A trustee needs to be able to do an accounting. So that's the last question I want to ask before we sort of talk about who should be in the role. So Julia or Kim, can you unpack what I mean when I say do an accounting?
I'm happy to take that one. There's a responsibility from a trustee's perspective, as I mentioned earlier, to account to the beneficiaries. According to our laws in our particular state, under the Uniform Trust Code, qualified beneficiaries, those who have an interest, let's say, down the road, either current or future beneficiaries. And so from an accounting perspective, what we have to do, obviously we are generating financial statements on a daily, weekly, and monthly basis. Those statements are going out to those beneficiaries, as well as, let's say, that if there is a co-trustee in place, to ensure the integrity of the accounts. We do that for a number of reasons, going back to, again, the concept of a duty of loyalty and a duty of care, a fiduciary duty. But ultimately, there is also a liability piece of this that is assigned to a trustee, be it a corporate trustee or a personal individual trustee. Trustees have been held personally liable for failing to certainly handle certain elements of their responsibility. And the duty to account is one of them. That has been, recently codified by New Jersey's adoption of something called the Uniform Trust Code, but it's something certainly PNC has always done with respect to our trust, that duty to account. We do it because of the transparency need, the communication need, the reality that it is our responsibility to do so, and to ensure that the beneficiaries are always aware of what is going on with respect to that trust. So accounting is a huge piece of the work that we do, ultimately, that any trustee needs to do, and that ultimately will certainly funnel into the preparation, as we mentioned, of those tax returns that are going to be due relative to these trust entities.
Okay, so we've got a couple of people who can act as the trustee. We have a beneficiary. I have to tell you, the default in most of my documents is that the beneficiary is the trustee. Why? Because they can hire a co-trustee or an investment advisor or an accountant or whoever they need on their team to be able to help them, okay? But sometimes the beneficiary is not ready to be a trustee. So sometimes they're 22 years old, and while they may be the smartest people in the entire world, they have no life experience for managing your assets that they are inheriting. They just don't have that there yet. So oftentimes in that case, I'll recommend a co-trustee arrangement, which is to say that the 22-year-old beneficiary at 25 becomes a co-trustee with somebody else. And maybe at 35, they become their own trustee, with the idea being that within that 10-year period, they learned all the stuff that we're talking about here today about what's involved in being a trustee, and they learned some of the basic skills, preparing and filing an income tax return. If you're 22 years old, you may not even have to file one. If a trust is earning money, it's got to file a return. So that's an idea to think about. A third party, a lot of times when people have younger children, I'm going to name my sister, my brother, my mother, whatever the case may be, that could all be very good and well, but I think that we really need to think about, are you naming them because they're the best possible trustee? Or are you naming them because they'll get mad at you if you don't name them? Remember, in this example, you're deceased, so it doesn't really matter. Or are you naming them because it was sort of your gut reaction, well, I'm going to name my oldest child to be the trustee because that's what makes sense, okay? Or do you do some kind of combination of these roles and to think about what it is that folks that, should really be doing? So I took some notes here, Julie and Kim, from what you said, and this to me is what I think people should be thinking about when who should be the trustee. Will the person be a good communicator? Which is to say, will they make sure that people are knowing what's going on in the trust? Will they be open to having discussions with people about what their needs are, non-judgmentally? Yeah, some people feel that they really do need a Ferrari. You might have to talk them down off of that one, but it's not a stupid idea. It's just that you need to maybe educate them about what the alternatives are that are out there. If you've got somebody in your family that's really awesome at books and records, but they don't really talk to anybody during the Christmas holiday party, that may not be the person that you want to name, because there could be friction there, not because they're doing anything wrong, but because the beneficiaries feel that they're being kept in the dark. Keeping good records. So Kim, you've talked about, this duty that we have of care and loyalty, our need to be able to say, here's what happened with the money. Well, if you keep really bad records, that's not really going to work out for you at all. The duty to hire an investment advisor. So Kim, you and Julia work together, but Julia, your skill set is on the investment piece. You're bringing a necessary element to managing a trust, but in this case, it's still two different people. Notice that Kim doesn't have all the knowledge in her head, that you have to have somebody who then is going to be able to bring into the idea, what do you need to do from an investment perspective, and how do you need to manage this? And that goes back to the idea of the team. And then finally, I think that they need to put the beneficiary first. When it comes down to the duty of care and loyalty, at the end of the day, it's putting the beneficiary first. Now, if they're the trustee and they're the only beneficiary, put yourself first. That's awesome and great. But think about, you got the money, it's inside the asset protection. But if you're the trustee and it's for you and for other people, give some, you mentioned the long view, right? Is the security, is it going to be there at the end of the day? And I think that's what many people struggle with when they inherit money, is like, oh my God, I just inherited $1 million. I'm never going to have to work again. That's false. Okay. I don't know. Maybe if you lived in the middle of North Dakota, $1 million would carry you for the rest of your lifetime. I can tell you it is not going to work in Northern New Jersey. So, so those are the sort of the kind of touchstones from a value perspective. Do you guys have any other, comments about it? Like what makes a good trustee?
Yeah, no, absolutely. I mean, you definitely have to know who you're naming, and especially let them know that you're naming them. We often see that it's a surprise, like, here I am, I'm a trustee, and they really didn't want that job. So I think it's not an easy job. It is a huge responsibility, and you do have to have some knowledge, especially when you have, for instance, we often see families that have 4 children. And they want to name the 4 children because they don't want to upset them. Wrong, not the best thing to do. Truly, we feel that if that's the case, you should name actually maybe someone outside of the 4 children. From our point of view, when you name a corporation, we like to say is we do all the heavy lifting, and we also avoid those fights at Thanksgiving. Imagine your daughter asking money to your son. It's not going to be very pretty. So I think you really have to think that money, unfortunately, does cause a lot of tension among families. And we see this day in and day out. They'll fight for the most minute thing. So it's important for you to really have an understanding of who you're naming, and also that they're educated enough that they're going to be very neutral and prudent at investing these assets per se. We're talking about, $1 million, as you mentioned. We've seen cases where they only will invest for the money for one of the beneficiaries, and the other money will sit in the money market per se. That's not the right way to do it. You have to make sure that you are equally ensuring that that money is growing and that it is invested prudently and appropriately to meet those needs, because you will be responsible for it. So when you choose a trustee, you need to know, and they need to know, that they have the responsibility, and it's huge. Kim, do you want to add any comments to that?
No, I think you summed it up very well, Julia. I would only add that, the concept of hiring all these experts to fulfill all of these duties, the taxes, the recording, the investments. Certainly when you serve in a trustee capacity, you have all those responsibilities. And if you don't have either that background or the demeanor, perhaps, to handle all the elements that are imposed upon you, these various duties, that can get very costly. And so very often, what you find with a corporate fiduciary is we have those services in-house. In New Jersey, similar to many states, there is a statutory compensation for a trustee that is allowed. There are other states, frankly, that view it at the reasonable compensation standard, and that's kind of set up by the case law in those respective states. But certainly with many corporate fiduciaries, including our own, we have a standard fee schedule, which is regularly published. And for that fee schedule, you ultimately will have the benefit of the portfolio manager. As Deirdre mentioned, look, I'm not a portfolio manager, but I rely on members of my highly skilled team to ensure the portfolio, be it property, special assets such as property, let's say, or investments, are handled correctly. You have a trust officer who is well skilled in interpreting the document and partnering with the respective family members to be in constant communication, and ultimately tax specialists to ensure that those taxes are paid correctly and on time. Those are all of the things that you need to be thinking about when you are considering a trust and, frankly, making a determination of who should serve in the trustee capacity.
Excellent. So if you can flip to the next slide. So if you have more questions about this, some people like to watch webinars, some people like to listen to things, some people like to read things. There's more resources either at Porzio Planning or at PNC. The final thing that I was just thinking of is being a trustee is a job. And Kim, and I'm going to go back to what it is that you said at the beginning. The project manager. So if the attorney is drafting the blueprint and is the architect of putting that together, and you are the client, you're the individual that you're coming up with this, give some idea as to who the project manager is going to be and if they can actually really take the job on. Think about any renovation you've done in your house, and maybe it took 20 months longer than they said it was going to. And is that the right person? And it doesn't have to be a corporate trustee. It doesn't have to be a family member. It doesn't have to be a beneficiary. It can be many, many things. But what it should be is something that you're really giving a lot of deep thought to in terms of who is it that should be in that role. So let me see. I think we don't have any more questions that I see here. So without that, it's 1:29 right now. We're sort of at the top of the hour that we had. We so appreciate you joining us today, whether you're joining us live or you're joining us after the fact. If you do have other questions, if you can flip to the next slide, Julia and Kim's information is available here. They're happy to answer them. And as I said, you can go to our website. And we love talking about this. So if you have questions, please, because not a lot of people want to sit around and talk about trust all day, which we clearly do because we were having fun during this. And with that, I will say thank you very much and good afternoon. And Julia and Kim, thank you so much for your time. I appreciate it.
Thank you for having us.
Have a good day, everybody. Take care. Bye-bye.
Bye-bye.